You're still watching This Morning on ITV. Up next is our first discussion segment, our news analysis segment. An intermediate court hearing an electoral appeal case arising from the 2003 senatorial elections after overcoming several overt and disguised attempts to stop it from delivering a judgment, eventually concluded hearing at the appeal and set a date for its judgment. On the date for the judgment, however, the members of the panel sitting over the case came up with two different decisions. The chairman of the panel told the judge, one of his members of the panel, to read the judgment that was purported to have been reached by the entire House, but he decided instead to read his own judgment. What happened afterwards was that the crowd moved in when the judge in charge of that committee decided to read the judgment that he said was the judgment decision of the House, and the crowd in the court moved in on them. Somehow they fled. We know the cases that followed that. Two justices lost their job afterwards. Today we are looking at fresh issues emerging from the Nigerian election tribunal system. What are they, and what implications will they have for us in the 2011 elections? I have two people in the House to discuss. I have a human rights activist, a lawyer, and a writer, Chief Nkere Onwem Akpan. Good morning, sir.
Good to have you, sir. Thank you.
It's good to welcome, sir.
Thank you.
And we also have a one-time member of the gubernatorial election tribunal of Borno State in 1992, and is the former chairman Plateau State Local Government Election Tribunal. We have Dr. Samson Sani Ame, SAN, is a senior advocate of Nigeria and a member of the Order of the Federal Republic. It's good to have you, sir. You're welcome. Good morning.
Thank you very much.
So we are looking at election tribunals in Nigeria. I want to start with you. Let me take Chief first. What has the story been like? I hope I know that both of you have been one on this side and the other on the other side. So let's get your views, sir.
Well, thank you. The popular view really has been that tribunals are an aberration in a democratic setting. Matters should be adjudicated upon in a duly constituted court of law, where you're going to have all the evidence taken in a methodological and very, very incisive manner, and a decision come to one way or the other. Now, in between that is the need to, because there's the maxim that justice delayed is justice denied. 90% of the time, the regular course of the land are wound to take lots of time, adjournments, all of that. But you have to balance this with the other maxim that delay defeats equity. Now that if you are too slow, someone is losing. If you are too fast, you don't want to sacrifice justice on the altar of expediency. Now, you have to balance. It's a delicate balance, really. But in a democratic setting, the popular view will be that matters should be tried in regular courts. But you have incidents that you need time to. Time is not on your side, like petitions.
Yeah, what's your opinion on tribunals? In one word.
In one word.
Or in a few words.
In a one word, it's a good thing. It's a good thing.
Okay, yes. I'll come back to discuss it. So what's your opinion on tribunals? We've seen them over the years. You have participated in some. What would you say is the story?
Well, just to repeat what he has said, because justice delayed, justice denied is the adage. Tribunals are a necessity in a political dispensation. They have always been there. They have been provided for in the electoral laws that we have always passed right from the time of Shagari and Awolowo. Tribunals have been there.
Okay. So I have had interactions with some civil servants, and civil servants working in their station may not be perform very well, but if you move them from their station to go and supervise another station, give them extra coats, give them night allowance, put them in a hotel, you see that they are working overtime. Now, how is this different from the tribunal? Because we see the same people who are slow in the courts becoming very active in the tribunal.
Thank you very much. In the court system, The judges are regular judges. They sit there. It's a permanent job. But when they constitute a tribunal, it's like a special assignment. It is given a time frame within which to finish and for them to return to their normal stations. So the frame of mind, the environment, the circumstances are quite different, and the level of concentration is much higher than in their normal posting.
Okay, so do you think we really need tribunals? Do you think judges can function in the way they function at tribunals in their regular courts?
Well, why not? If you look at the constitution itself, there's provision for tribunals. It says if a man to hold before a court or other tribunal, I mean, the constitution recognizes that there ought to be tribunals, but like what Ellen
now, when we are talking about speed, what stops the speed we have in the tribunals from being obtainable in regular courts?
The popular, jurisprudential speaking, we say that you need not sacrifice justice on the altar of expediency. Now, what that means is that because justice delayed is justice denied, you have to strike a balance. And that striking of a balance is to move the petitions at trial stage to tribunals. Because if you bring an election petition, because in the trial court, really, all the evidence will have to be used, witnesses called, all of that process. But in the tribunal, they are laid down guidelines to cut most of the bulk of the workload. Now, it is only when you have to go on appeal, that appeal will then be in a regular, appellate jurisdiction. That's the point.
Okay. Now, so let's look at one of the major issues in cases in the country, and that is the cases of delay and adjournment. What would you blame for these delays and adjournments? Would you want to blame it on the lawyers who think the more appearances they make, the more legal appearances fee you get? And I hear, I mean, this is not me, I'm very careful talking with lawyers, that you get appearance fee for not appearing even.
No, you have a learned SN on the board, so you have to watch. You have to watch it. But let me before he chips in, I'm sure you have something to say about senior lawyer, but let me speak for some of us who are not SNs yet. I don't have the time to go to court a zillion time for the same matter. If I can do it at 2 adjourn, why do I have to postpone adjourn for like forever? I don't have that kind of time. There's some 2,000 or 3,000 emails in Kuje prisons that need your attention every day, all over the country. Now, but let's be honest. If a matter is intricate, you have matters that have to do with foreign exchange, somebody send a Yahoo mail somewhere, you need to investigate properly, bring all the evidence to court, subpoena the witnesses and all of that, you need time. Some of the adjournments are truly necessary. But 90% of the time, see a senior lawyer send a junior just to go and take a date. That makes me so angry. And I hope the LNSA will shed more light on this one.
Yes, I was going to do that.
Yes.
Now, before, because that's what I was saying. You just go, maybe that's some form of appearance. If you just go and say, okay, I want to take a date, and then your client will have to...
No, I concede that grant to the LNSA. Let me answer that.
Yeah, but I want to say something. Now, I was in a court case as a reporter once, very recently too, and one of the things I noticed was that the case was instituted in a court, in an Abuja High Court, which has no jurisdiction to try that case. And this was instituted by a very senior lawyer. Now, why would you want to waste the time of the court, for instance, when you know that this court has no jurisdiction to try this case, instituting the case before that court in the first place?
Well, just last week, a couple of weeks, I was in a matter, I'm not going to name the matter, it was all in the papers, and all we told the judge, the matter that was supposed to be at the FCT High Court was taken to the Federal High Court. And we told the judge in English, in simple terms, my lord, this is not the forum. You have no power to even look at the charge. The proper person to look at the charge is my lord Gumi CJ of the FCT High Court, not Dan Diabuto of the Federal High Court. Because if you go ahead and deliver a judgment, believe me, all we need to do is to wait until you deliver your judgment. And then we go on appeal. And we said that the man the judge delivered the judgment had no power to do so. And this is fundamental. The matter will be thrown out and sent back to the proper court for a trial. But now sometimes we have seniors who give their brief to juniors to prepare, and they go to the wrong court to file because of the bulk of cases you can imagine. Because I don't see why a very senior lawyer who go to the wrong court in the first place, except for mischief, But that's not our talk. So I suspect that 90% of the time it is a honest mistake to go to the wrong court. Well, I am not. And listen, like I said, I want the chief why senior lawyers go to, the wrong court. Like in the matter we were talking about last week.
Thank you very much. Yes. Let it not be a dispute between senior and junior lawyers, but let's look at it as a problem.
Okay.
And I entirely agree that a major issue now is delay in the dispensation of justice. Actually, it has become a topical issue and measures are being taken to remedy the situation. But be that as it may, the blame, it's not easy to blame just one person or one segment of the society. Perhaps it's part of the effect of our society in general. I know that counsel, that is to say lawyers, are usually blamed for delay, for asking for unnecessary adjournments, for not appearing in court when they should appear. I think we share that blame considerably. But I think much is being done to tackle the problem of delay in the dispensation of justice. Now there are rules. In fact, the setting up of election tribunals themselves is an admission that delay should be curtailed so that if the cases go to regular courts, they may be very much delayed. Hence, we have tribunals so that the cases can be fastened. Be that as it may, the processes are being put in place to now cut down the length of time spent in the dispensation of justice. You have special regulations, you have rules, you have practice directions. All these things are being put in place to ensure that there is no further delay in the dispensation of justice.
Okay, so that we don't digress too far, I love discussing the judiciary, but let's focus a little more on tribunals. We understand that the Constitution allows for tribunals to be set up. Now, but we had brought in delays as one of the major issues against justice. As you had mentioned before, justice delayed is justice denied. But let's look at one of the other issues that also worry on delays. Tribunals, the role of tribunals, you want to say, one of the issues is joining of parties to a suit. We had a case where about 3,227 respondents were joined in a case. I think I won't be able to tell you what case exactly because my printouts are very tiny, but 3,227 respondents were joined in an election tribunal case. What's the position of the Electoral Acts on joining of parties?
Thank you very much. That has become a problem. It's becoming, these matters are becoming unwieldy. The requirement is that so many respondents should be joined. And there was an effort in the recent Electoral Act of 2006 that if somebody acts or performs a duty on behalf of INEC, Independent National Electoral Commission, and INEC is a respondent, that person is treated as an agent. He need not be joined. So there's that provision to cut down the number of people who would appear as respondents. So that is an effort made. But the issue is that we are operating a written constitution, and each law is subject to the provisions of the constitution. That provision was read against the constitution, and the issue of fair hearing arose. And I think there is what we may call a middle course being adopted by the courts and the tribunals. Yes, somebody who performs a duty, an electoral duty, is acting on behalf of INEC, and once INEC is a respondent, he need not be personally joined. But at the same time, the issue arose that if you make an allegation of a criminal nature against a person, he must be made a party to that case to enable him defend himself. That is why you have so many respondents. If somebody is alleged to have forged voters register, if somebody is alleged to have stuffed ballot box, that is a criminal allegation of fraud, and therefore he must be made a respondent. That is why we have so many respondents.
Okay, I'm sure you want to say something, but allow me to add something to it.
Okay.
The case in question is that of Ugochukwu Agbala versus Chimaroke Namani, and we are told that the respondents whose name or official descriptions took about 71 of the 77-page which constituted the petition. But let's add quickly, there's one more thing that we are also talking about. Issues of the petition not certified or not signed by the petitioner, and sometimes you just see that the registrar or the clerk who should approve, just for very flimsy excuses, throws your petition out. What's the position of the law as we look at this? Because these are issues that actually bring about delays in petition and tribunals.
Now let me take that shortly. Is it the beauty of petitions is that they are lawsuits of a special genre. They're not your regular lawsuits. So in petitions, they love technicalities. If it's undated, if it's unsigned by the proper part, anything, the slightest, you struck out for being incompetent. And all of this is to save time too. But a regular court, they will say, well, signature, they can, maybe there's a way to go around. There may be a way to go around it. But at tribunals, because the court somebody have won an election, he's been sworn into office. Somebody challenging that election. And perhaps for a 2-year term or 3-4-year term, it is the man maybe like this. You still have petitions when the election are coming back in January. So the tribunal want to do everything to ensure that they spend the matter before them. Now, on the issue of having 1,000 names on as respondents, you see, like the letter SAN said, when you allege that an offense has been committed, which is fraudulent, or something like forgery, like stuffing a ballot paper and all of that. So somebody hijacked the ballot papers and ran away. Now these are a crime against the state. Now the law is clear. A man who's been accused of committing an offense has to be heard. You said this. You said one resident electoral commissioner in Ogun State or in Soso State picked the ballot box, and you say you want to try him by proxy through his principal in Abuja. No, ordinarily, because if the principal is known and has been sued, needless to sue the agent. But because you say an offense was committed by the agent, then there's need for the agent to come to court and explain. Right to fair hearing, and it's constitutional. So you have to balance the provision of the Electoral Act and that of the Constitution, and 100% of the time, the Constitution prevails because of the supremacy clause in section 1 sub 3 of that Constitution.
Okay, I'm sure he will want to say something about it, but time is really not on our side. So I want to move to something else. You are at liberty to add 1 or 2 words on this before you answer my question. But what we are looking at also is one major issue that has become a challenge even with the Justice Ways panel, with the National Assembly, and with the public on issues of election and election offenses, and that is the issue of the burden of proof. We have been told that mobilizing evidence and the burden of proof should be on the part of INEC. And others are saying, no, if you have a cause, you should prove your cause. So what should we choose here?
Well, thank you very much. I am impressed by the innovation. I really appreciate the recommendation made by Justice Ways that the burden of proof should now be on the respondent rather than the person alleging. That is contrary to the common law Western legal philosophy which we have adopted in this country. But to me, I like the innovation, and that is the way it should be. We should not just be copycats. If circumstances are different, the laws should be different. And it's an innovation. And I think it is even a good innovation, because when somebody has been rigged out of the election, somebody has lost, he may not be in a position even to establish anything because he has been kept out. And it's the insiders, the people who conducted the election, they knew what they did. And you are asking somebody to come and prove what he does not know. What he has, you want him to establish facts that he has no access to, materials that he never laid his hands upon. So to me, it is a good innovation. We don't need to follow the Western common law system of burden of proof. The burden of proof, the onus can be on the respondent for a change. Let us see how it works.
Yeah, so I am sure you have handled a lot of election petition cases, but very frankly, do you think a party to judicial proceeding should not bear even though you are initiating, it should not bear should we not trust INEC enough to be able to provide information and evidence that you need, even though it may indict INEC?
See, you have our Evidence Act is clear, burden of proof, like the SN said. A man who has, if I say this to my staff, I should come up with how I can buy the staff. Now, if I ask him, who is saying that this is not my staff, to prove, it is difficult, like he pointed out. How is he going to prove that it's not mine? To prove the negative, it's very difficult. Now, but you have a challenge. You are asking a man who ostensibly or allegedly rigged you out to come and admit that, yes, I rigged you out. It's like standing logic on its head. It's moronic, because now, if Mr. A won an election, allegedly so, with the help of INEC rigging the ballot for him, Mr. C, Mr. B goes to the tribunal, and you're asking INEC to come prove, admit their guilt, that they actually rigged. I think we have a real challenge there. It is going to be extremely difficult. You're going to be sure that the way our electoral acts are tailored, it is meant to favor the man who won, by whatever means.
Yeah, but what happens to our interlocutory orders? We have them, others like Mandamus telling the courts and a few other orders telling INEC, for instance, to produce evidence. What happens to them? Don't you think lawyers are beginning to become a little lazy?
But they got to bring the documents that they have. And they're likely to keep the ones that are going to incriminate them in the files, or burn them or destroy them. See, nobody's going to bring a document to court that's going to show in real time that he rigged the pool, or that he collected $1 million to bring somebody into National Assembly. How do you expect that? I mean, let's be reasonable. There is no way on earth INEC is going to bring a document to show, incriminating itself, that it actually aided a party to win an election. So that's the challenge. It's kind of tricky.
But let's look at it a little differently. In the first instance, we are saying, I am bringing a case against INEC, and I'm saying the law says I should prove what INEC did, and I'm saying, okay, I am not competent.
Yes.
Now I am bringing the same case against INEC, and I'm saying, INEC, prove what you did. Are we not saying the same thing? Are we going to get anything different in the end process?
Well, it depends. We may. The way the law is structured, we can still achieve the same purpose. As my learned friend has mentioned, he who alleges the negative has no onus of proof. But he who alleges the positive has the onus of proof. If INEC is saying that, yes, this is the winner of the election, this is the result, these are the facts, by virtue of subpoenaing the documents, by not giving them perhaps an opportunity to doctor documents, to establish a case, perhaps immediately if the matter goes to the tribunal, INEC should be ordered to surrender all the electoral materials, all the materials used into the possession of the tribunal, and then it becomes a matter of examining the materials used and then arriving at a conclusion, which may be different, because I agree with him, INEC will not come and confess. The person connected will not come and confess that, yes, what we did is wrong. But if documents speak for themselves, and documents do not lie, and then the court said that in a matter of documents, any court can be like a trial court. Once you look at the documents, you can come to a decision. Perhaps it is possible to compel INEC immediately after the election, surrender the materials, and then we will examine the materials at the tribunal.
Okay. Let's look at time. Time is not our friend today, but let's take a little look at decisions, also suggestions from the OAS panel saying that all election cases should be dispensed with before candidates are sworn into office. Do you see this possible?
It can work. It
Why-
cannot.
why would you
it is
say
difficult.
this?
And let me tell you.
Because lawyers like you will not allow it.
Oh no. Let's see. Let's be honest with ourselves. You have the elections on. Say on the first of, and you have between the day the election where the results were announced and the swearing in is like sometimes
Like 3 months we are going to have probably. We
90
have
days.
elections in years.
Okay. Now, if it is one chairmanship election in one local government, you see, it's a small crowd. If it is the National Assembly election, you probably need a series of constituencies. If it's a governorship election, then you need the entire state. If it's a presidential polls, for God's sake, there are 36 states and Abuja. Now, you need to collect all of that evidence. You need to go around. You need to subpoena witnesses. I am not sure that that's going to work. But let's even assume.
Yeah,
that
for
it's possible.
time's sake, I just want you to add what
Yes.
will work. Maybe you just add that because of time.
What will work is that the man who allegedly won is sworn into office, continues to represent his constituency until he's got a replacement, so as not to leave a void.
No matter how long.
No matter, I mean, I will be angry that there's nobody in National Assembly representing my
Yeah, but
constituency.
should there not be a
because-
way to compensate you if you came in only 1 year into out of your tenure, if I will say that? You like we have a senator who was sworn in this year and to represent his people to do
And
what?
that's a different ball game altogether. Truly.
Yeah, but that's your suggestion.
well, but they had a representative.
Yes.
There was somebody in that place.
You
who
don't have a
sat on the
problem
chair.
with a wrong representation.
Wrong in the sense that somebody was declared the winner and sworn into
Wrongly,
office
in error.
legally. He was in the office, but in fact, he didn't actually win the poll. But at law, he was sworn in properly.
Yeah, but he was not the winner by law. Now, one law does not override the other. I think we'll come back to you for a final word. So let's look. You've been at 2 election petition tribunals sitting, and I'm sure you have a wealth of experience. But do you see this working at all?
Oh yes, the arrangement so far is working, and I agree entirely with my learned friend here that once an election has been conducted and a result declared, the winner, the alleged winner, should be sworn into office so that there will be some sort of stability, consistency, so that there will be no, as he has said, no vacuum, so that government will run. And even as it is provided, even if the petitioner wins at the tribunal and goes on appeal, the person there should continue just for the purposes of stability, because it goes beyond the person. This is a public office. This is a political office. It's not like a civil service that you remove somebody and the next person go and reports in the office. Here, so much protocol is involved. A person is sworn in, a crowd is gathered, and the oath of office is taken, and there's some celebration. If you begin to bring the other person that, oh, because you have won at the tribunal, he should be sworn in, there's tendency to be a clash between the former
Policy
person
and all of that.
and the new person. Therefore, for peace to reign, it is better. The arrangement at the moment is better that the person should continue. I think the cases...
Yes, would you not suggest that we extend the period between when we go to elections and when we actually get people sworn in, so that we can get the courts to tighten up and take decisions faster?
Well, that would be very difficult, because as my friend has said, some of these cases cover very large areas. Many, as you have said earlier, many respondents, many people have to be heard. I think that the present arrangement perhaps is the best. But let me add, it is a learning experience. It will improve with time. It will not continue to be like this. Let us not be stampeded because of one bad experience to change the whole law. I think next election will be highly transparent from what the president has done by example, and we may not have too many election petitions.
So a final word for Nigerians, especially lawyers who are hoping to make a lot of money from the next election.
Final word. Corruption is a problem. if you have the best laws, I've spoken on this channel and several other channels. Look, corruption is a problem. Get the best minds, get the best laws. When it comes to implementation of the said law, by the best mind you think you have had, you have a problem. Now, and I said to my mom, somebody comes to you with a bag of salt, certain tubers of yam, to vote for him. You will not finish the yam in our barn.
Yeah, that's because you bought yams or you have yams.
Now I'm coming. It doesn't even matter that they don't even have the yams.
Okay.
Now, what do you expect of that man who gave you a bag of salt for you to vote him in as a councillor?
Yeah, so I want you to say in very few words, how can we move forward, because really time is used up.
The anti-corruption crusade is a crusade we must win. When we win that, it trickles, it dovetails with every other aspect of a national
I'll
polity.
take that as final word. Thank
That's
you very
right.
much. So final word on it.
Yes, I believe, and I'm sure we are moving forward. Let every vote count. I think even the media education, our people will be educated, and transparency, orderliness will come into our electoral system. And it's a gradual process. It's not something that can be done overnight. Corruption will eventually fade away, but it's a question of time.
Okay, I must thank you very much for coming.
It's a pleasure.
I wish we can have more time, but we really don't have that.
Thank you so very much.
Now, Nigerians, there's so much we can take. On our news analysis segment, we've been looking at election tribunals and the 2011 elections. We have hope that things will be better. I had on set with me Senior Advocate of Nigeria, Dr. Samson Sani Ame. He was a member of the gubernatorial elections tribunal in Borno State 1992 and former chairman of Plateau State local government election tribunal. And we also have a human rights activist and a writer, Chief Nkerem Uyen Aka. We'll take another break now. When we return, our next discussion segment will be up next. Do stay with us.